Greetings and welcome back. We're in Chapter 8 now, and we're going to be talking about authentication of documents. And generally speaking, it starts off with just talking about what a document is. And it starts off very similar to the way Chapter 1 discussed evidence and this idea of what is evidence. And we said that evidence is really everything at this point in time. And then we kind of learned that the evidence is, we are going to put some some limitations on it. Relevancy, the prejudicial effect of it, character evidence. These things kind of put the idea of relevant evidence and all evidence is admissible in the check and create some barriers. Same thing goes for documents. Everything's a document. And that includes, a regular piece of paper, a document like this document. This book, if I ripped out a page, it would then be considered a document. It can mean the metadata on when you're typing in on a Word document, the indications of a button being pushed. That's considered metadata. That is considered a document. The graffiti on a wall your book mentions a document. Everything's a document. Very similar to everything is evidence. And because of this, we had created, Rules of Evidence have created some rules, of course, that limits the use of certain documents. Because we don't want to just flood the gates with documents. And on top of that, we want to make sure that whatever the document is, it is what it's purporting to be. We want to make sure that this is the document that is necessary to prove or disprove a fact and issue. And in order to do that, the book discusses, and the Rules of Evidence have rules on authentication. There are two types of authentication that we're going to focus on. The first one is self-authenticating, and the second type of authentication is additional evidence to authenticate. Those are the two types of authentication we're going to talk about. The first type, self-authentication, is where the document itself authenticates itself. You don't need anything more than the document. Now, you might need someone to testify regarding, like, yes, I did in fact put that seal on there, or yes, this document is something that's kept in our regular course of business. But to say that this document is, a prior felony conviction, a sealed conviction, or it's a will, or no one needs to say anything else because it's been self-authenticated in some way. So what does it really mean that something is self-authenticated? What it means is that the law presumes it is what it says it is. That's pretty much what it means. And there are several different categories of self-authenticating documents. And I'm going to go into a couple of broad general categories here. First one is sealed government documents. Anything with the government seal on it is going to be considered a self-authenticating document because that seal is what authenticates it. And you don't use the seal for just any happenstance thing, right? It's the government seal. It's a very important thing. And I can tell you that many people are sensitive about it when it's improperly used. So there's some validity into its use. And when we see it, we say it's self-authenticating and there's nothing you need to worry about at that point. Then there's notarized documents. I'm sure at some point in time in your life, each one of you have gotten a document notarized. And pretty much all it is, the notarization process, as you've all been through, is you fill something out and you sign it, and then you take it to a notary, and they say, hey, let me see your identification. You produce some sort of ID, and they check the ID with the name on there, and they ask you, hey, is this you? And you're like, yeah, that's me. And then they're like, great. And then they stamp it and sign it themselves, and they put the county and where they're registered. That's a notary stamp. And that's a self-authenticating document. Used quite a bit. I've used it quite often. I've had to get documents notarized, and I've also been privy to notarizing documents before. As an attorney, I am a notary, so I can do that. This other thing is acknowledged documents. This is a little confusing because it can be confused with a notary, with a notarized document, and in reality, it's almost it's an attestation, and it's used for wills a lot. And the idea is that we don't want to have to bring someone back into court to testify to their signature. And what I'm talking about that is like it's a will requirement to have a couple witnesses sign a will, and if they don't attest to their signature, i.e. acknowledge the documents, then they will have to be pulled back into court to testify about this will and signing this will and knowing that it was a will and they were told it was a will and a bunch of other formalities. And it's not really necessary for a criminal justice process, but it can, if it's not done on a will, it can be a really big headache when it needs to be probated. And then official publications are self-authenticated. The first three types, there was some sort of stamp or seal or something like that. Official publications, I'm specifically talking about things that the government itself produces in like a book or volume format. And that can be like the United States Code, the West Virginia Code, these things. The government themselves, the West Virginia legislature actually, has money in budgeted to have someone officially publish their laws. Same thing with the United States government and every other state. The same thing goes for the judicial branch. The judicial branch themselves, the things that they publish their court opinions in, those things are bounded in a book, and they're called reports in some places. They're called a lot of different things, and registers another one. So these type of things, they're just bounded and they're official publications, but they're considered self-authenticating. So not really the same process as the previous three where there's like usually some sort of stamp and signature. This is a little bit different. But those are the self-authenticating documents you would usually come across either in real life when we're talking about acknowledged documents, or documents like a sealed government document, notarized document, or official publications that you'll encounter in your professional life. The more important ones are going to be documents that require additional evidence, and this is where your investigation practices are really going to have to be honed in, because you might find a document, say for example you find some sort of document like a handwritten letter, and you're going to need someone to testify to the authenticity of that handwritten letter. If you want to use that letter and say this letter was written by so and so, and it may be the defendant, might be a victim, you're going to have to be able to produce someone who can identify the handwriting sample there, who can also identify that it was produced at the crime scene, that you obtained it there. Not produced, but obtained it. So let's talk about some ways you can get the necessary additional evidence you need to authenticate that document. And that would be, for example, the testimony of a witness. That's an easy one. You can get the person who actually wrote it, or the person who actually produced it, person who actually has personal knowledge of that document to testify about it. You can also get the lay opinion of a witness as well. That's a little bit different than an expert opinion. A lay opinion is the idea that the witness doesn't have personal knowledge, but they can testify regarding their opinion on something. And this is also different than the opinion on character evidence, because this is actually going to the document itself. For example, let's go back to the handwritten letter, and it belonged to the victim. The victim in a murder case, of course, is no longer around to testify to that document's accuracy. So maybe you go to a bank, the same bank that this victim went to every day for 5 weeks in a row. And for 5 weeks in a row, they signed something in their handwriting every day. You could get the bank teller that serviced the victim those days over the last 5 weeks to testify to the handwriting that's found in the document and have the opinion to say, yes, in my opinion, that letter was written by this victim because I've observed the victim's handwriting before. And it's their opinion that the two match. They can't conclusively determine that it is. It's their opinion. And they can do that. That's allowed because it's based on a perception. It's based on some sort of sensory perception. Their observations, their hearing, their taste, touch, all those things. Those are sensory perceptions, and they can give an opinion about them as long as they have some personal knowledge, some foundation to establish the credibility of their opinion. Again, they can give that. So that's a lay opinion. And please remember that, sometimes you'll find something written in someone's handwriting and you might go, this would be really useful, but I don't know who it belongs to, but I think it belongs to this person, but I have no one to back that up. I have nothing to go with that. But then if you do a little digging on your own, you might discover that someone can testify as to the handwriting of that, and you don't have to get an expert to do it. You could get a lay opinion, and sometimes that is better because the credibility of a lay opinion, well, they relate more to the jury. There's pros and cons to lays and experts, but anyway. So then you can get also a forensic document examiner. That's an expert witness, and their job is really they have the specialty of understanding handwriting, and that's just what they do. That's their expertise, and they can conclude as well as whether or not the handwriting is so-and-so's, right? The lay opinion couldn't do that. They could just give an opinion. The expert, it's not really an opinion. They conclude on whether or not the handwriting is the same. And the last thing is public records. And this is a big one for police reports. More than, public records is, a giant thing. As long as there was authority to do it, and the law required them to do it, that's a public record. And police reports, they had the authority to do it, and they have to do it by law. That's a public record. So these things, they require someone else to authenticate them. And with a police report, you're going to get the person who wrote it, you're going to get the officer who wrote the report. But sometimes you don't always need the police officer to authenticate it. That's the important part. Sometimes you can get someone who is familiar with the practices of the police department to testify to the authenticity of the police report. Other things could be anything. Think about the Social Security Administration. How many things that they document on a regular basis as part of their regular course of activities, and are also a part of their authority and requirement by law. Those were plenty of those out there. So let's delve a little bit deeper into this use of forensic examiners. I want to kind of set up the parameters so that you can understand the difference between using a testimony of a lay witness and the forensic examiner. Just so you can, we've got some questions coming up soon, and you're going to need to know this information. I want to make sure you clearly understand something very unique about getting enough information for your expert. So you need an adequate sample, right? You can't, you might have something written already, and you might compare it to something else, and a lay witness might testify, well, yes, that looks the same, because I'm familiar with both. An expert witness, forensic document examiner, will say that the two look consistent. But if you really want a conclusion, you're going to have to get an adequate sample from the defendant themselves. Or not necessarily a defendant, you can get it from anybody, but most likely it's going to be a defendant. And you're going to have them write out a few hundred words. It's usually like a paragraph, and there are certain words in that paragraph that are used to identify the defendant's handwriting and that the forensic examiner is going to use. The thing I want you to understand about doing this, right, you're telling the defendant right now, you have to write this. And as this entire class is about understanding that the defendant has certain constitutional rights. And you have the right to tell him he has to write that, because there's no Fifth Amendment right there, right? The argument goes that if I make you write that, and it does turn out to match this other document that kind of links you to the crime, well, then you've just incriminated yourself, which is a violation of the Fifth Amendment and requires you to Mirandize me, give me the right to counsel, all these sort of things. And that's not the truth. The truth of the matter is that you don't have a Fifth Amendment right to writing out something, or even speaking, for voice identification. The reason why is because the Fifth Amendment right is a testimonial privilege, right? So it's about what you're saying, the substance of your statements. So as long as you're not incriminating yourself, right? I guess what I'm saying is like if those few hundred words didn't require him to say I'm guilty of so and so crime, right? If it just was, if it was just a basic paragraph, that's not incriminating, because we're just getting physical evidence. We're getting some sort of real evidence there, And that's not protected by the Fifth Amendment, just testimonial incriminating statements. What does apply is the Fourth Amendment. The Fourth Amendment does apply because in order to get that information, to get that handwriting example, you've got to have him in custody. You have to have stopped him. You've had to have seized him. Or he's got to be present with you in some way, shape, or form, or she. And that's where the Fourth Amendment can come into play. If you didn't have authority to have him sit in front of him or her to sit in front of you and give you that example, you may have violated the Fourth Amendment against unreasonable seizures. Not a search, but a seizure. And so that's an important thing to understand. The Fifth Amendment's not going to apply, but the Fourth Amendment may if you've seized him. And the only way that the Fourth Amendment wouldn't apply is if you had some sort of reasonable suspicion or you had some sort of probable cause to arrest him, actually, because to get a handwriting example, I think you would have to have probable cause to arrest. Or the defendant voluntarily came and sat before you and said, yeah, I'll write that out. Those are the limited circumstances that you will regularly encounter. So that concludes the discussion on Chapter 8. There's a lot more other information here about models, maps, and diagrams that will be tested on. I strongly encourage you to understand that information, but I want to make sure you understand documents. It's everything. We have to make sure that documents are authenticated. How do we authenticate? Some are self-authenticating. Some we have to get additional evidence, most of the time through some sort of testimony, to authenticate the document. And then finally, if you decide that you're going to use some sort of forensic examiner, you need an adequate sample from the handwriting of the defendant, and the Fifth Amendment does not apply, but the Fourth Amendment does. With that, I'll see you for Chapter 9. Have a wonderful day.